Thank you, Mr. Chairman. Thank you, Mr. Holder, for joining us today. I understand that the House Judiciary Committee has issued a request, I believe it was this past Friday, for documents and witness interviews related to Justice Kagan's involvement in the health care legislation and related litigation during her service as Solicitor General. Will the Department of Justice comply with that request?
I'm not familiar with that request. I'd have to look at it. I'm just not familiar with the request that has been made or what materials have been sought in that regard.
Okay. I believe the intent of the request is to get at any documents or any other indication that Justice Kagan, while serving as Solicitor General, may have participated in discussions related to actual or contemplated anticipated litigation involving the constitutionality of the Affordable Care Act.
Well, I can tell you that certainly one of the things that we did while she was Solicitor General was to physically, literally move her out of the room whenever a conversation came up about the health care reform legislation. I can remember specific instances in my conference room where when we were going to discuss that topic, we asked Justice Kagan to leave, and she did. So
So that being the case, there shouldn't be a problem complying with this request?
Again, I don't know what the nature of the request is. We can certainly look at it.
Okay. Yeah, there were letters. One was sent on Friday from the chairman of the House Judiciary Committee.
Okay.
You've acknowledged today that mistakes were made, obviously, within the Department of Justice related to the Fast and Furious program, but without specifying who made those mistakes. I'd be curious, what mistakes have you made that you can identify, that things that you wish you had done differently? Any mistake that you personally have made?
Well, I think that, as I look at the information as it was brought to me, I think that I acted in a responsible way by ordering the Inspector General investigation, by issuing the directive to the field. We have an Inspector General report that will look at this matter, and I think that we will glean from that report a better sense of what people did, who should be held accountable. And I want to make clear that on the basis of that report and any other information that is brought to my attention, those people who did make mistakes will be held accountable.
And you've reiterated several times that people within the Department of Justice believed that the initial statements denying knowledge of Fast and Furious were accurate. They believed they were accurate. Obviously, these were some people and not all people,
right? Because
clearly some people knew.
Exactly.
What can be done then to bridge this gap in the future to make sure that the some communicate with the others, particularly those at the top?
Well, one of the things I hope will be that as a result of the directive that I have issued, that with regard to this whole question of gun walking, that people will understand that is simply not acceptable. But the Inspector General report, I think you make a good point. The Inspector General report, I think, will ultimately answer a question that I don't know the answer to right now. Who actually thought this was a good thing to do, and why didn't people discover sooner than they did that, in fact, what we thought was occurring, in fact, was not? And I think that will be the result of the the Inspector General report.
I've been curious about some statements made recently by Lanny Breuer, the head of the criminal division, that are at once indicative of a broader concern and also, I think, in some ways likely to implicate some questions related to Fast and Furious. Mr. Breuer has stated that although he and/or his top deputies approved several ATF wiretap applications for Operation Fast and Furious, as is required under federal law, consistent with Title 18 of the U.S. Code, Section 2518 et sec. Main Justice has only one role in reviewing the sufficiency of wiretap applications, quote, to ensure that there is legal sufficiency to make an application to interrupt communications, that is, to ensure that the government's petition to the federal judge is, in his words, a credible request. He went on to explain that it's the responsibility of the district offices carrying out the investigation, quote, to determine that the tactics that are used are appropriate and that Main Justice has to rely on those prosecutors in the field and not to second guess them. I find this interesting in the sense that here the requirement outlined in Section 2518 of Title 18 requires an analysis at the Department of Justice level. It requires an analysis of you or of your deputy or of the Assistant Attorney General in charge of the criminal division, one of those officials, essentially. And one of the things that they have to do there is rather than simply regurgitate back out the same facts and say, well, that looks like they cite the right statute, they have to undertake an assessment as to such issues as, have other investigative tactics proven inadequate? And if so, why is a wiretap, which is a pretty extraordinary remedy, it's a pretty invasive investigative tool, and that's why Congress has understandably required that the Department of Justice at the top levels approve these. So if he, in fact, approved multiple wiretap applications, then one of two things, I think, is happening. He's either not complying with that duty to assess each one independently to make sure that there was this representation made, that the department established the case for a wiretap application, or on the other hand, he was doing his job and was therefore made aware of what was going on with Operation Fast and Furious, but didn't disclose that. Or when he saw initial denials by the Department of Justice about Fast and Furious, failed to raise the flag that said, hey, this is a concern. So which is it?
Well, first off, Lanny Breuer would not have approved, he would not personally approve these requests, these wiretap requests.
Would it have been one of his deputies?
Yeah, one of the Deputy Assistant Attorneys General.
Who report directly to him?
Report directly to him, but my guess would be that given the volume of these things, the conversations about those kinds of things probably does not exist. The only one that the Assistant Attorney General is required to approve personally is if it's for a roving wiretap. There were no roving wiretaps in connection with Fast and Furious.
Given that they report directly to him, wouldn't they be in a position, once they saw that the Department of Justice and its good name were on the line, to have said, hey, you know, the Department of Justice did in fact know about this program. In fact, we have approved a significant series of wiretap applications on this point.
Yeah, I don't think the wiretap applications, I've not seen them. I've not seen them. But I don't know, I don't have any information that indicates that those wiretap applications had anything in them that talked about the tactics that have made this such a bone of contention and have legitimately raised the concern of members of Congress as well as those of us in the Justice Department. I'd be surprised if the tactics themselves about gun walking were actually contained in those applications. I have not seen them, but I would be surprised if that were the case.